3, 2, 1, start. According to Mr. Bandopadhyay, no reason is forthcoming as to why the report under section 66 within bracket 2 of PMLA was not shared with the state police, and as to why the ED directly approached the writ court seeking appropriate direction upon CBI in terms of the ECIR dated 24th June 2022. Stop. The onus of launching an investigation in respect of offences under the Indian Penal Code is upon the state police. Stop. Judicial intervention in exercise of writ jurisdiction is warranted on account of obstructions to the investigation process, such as material threats to witnesses, the destruction of evidence, or undue pressure from powerful interests. Stop. It is only in such circumstances the writ court can play a corrective role to ensure that the integrity of the investigation is not compromised. Stop. ED filed the application though it was not even arrayed as a party respondent to the writ petition, and in such circumstances it was not viable for a writ court to order the initiation of an investigation. Stop. Surprisingly, in the present case, even before commencement of such investigation, the writ court has been approached by the ED so that such investigation may be initiated by CBI. Stop. From such sequence, it is explicit that with the sole intent was to sidetrack the state police. Stop. In support of such contention, reliance has been placed upon the judgment delivered in the case of Kunga Nima Lepcha and others versus State of Sikkim and others, reported in 2010 4 SCC 513. Stop para. In the application filed by the ED, allegations have been levelled against the Department of Urban Development and Municipal Affairs, but the said department was not even a party to the writ petition and did not even get an opportunity to meet the allegations contained in the application filed by ED. Stop. From such sequence, it is explicit that the direction for investigation to CBI in respect of municipality matters is also violative of the principles of natural justice. Stop para. Mr. Bandopadhyay strenuously argues that neither the accused nor the complainant or informant is entitled to choose their own investigating agency. Stop. In the present case, where ED was not even a party, an application was filed at its instance and an order was obtained from the writ court upon CBI to investigate in respect of recruitment in municipality which was not even the subject matter of the main writ petition. Stop. Mere complaints cannot be converted into suo motu proceedings for setting the criminal law in motion. Stop. In support of such contention, reliance has been placed upon the judgment delivered in the case of Divine Retreat Center versus State of Kerala and others, reported in 2008 3 SCC 542. Stop para. He further argues that the sequence of facts would reveal that ED had quick-witted the learned court in obtaining a direction towards investigation in respect of recruitment in municipalities. Stop. Without coming to a definite conclusion that the materials disclose a prima facie case calling for an investigation, the learned court passed such direction abruptly on the very date the application was filed, without noting that on the said date there was a resolution adopted by the three wings of the bar at the High Court that no adverse and/or ex parte order shall be passed on the said date. Stop. On the very next date, CBI in a hasty manner registered RCO 102023A005 dated 22nd 04 2023 under section 420/468/471/120B/34 of IPC and sections 12/13 within bracket 2/7/7A/8 of PC Act, and the officials of the municipalities and the government officials may be arrested any time, and such threat perception affects their fundamental right. Stop. In support of such contention, reliance has been placed upon the judgment delivered in the case of Secretary, Minor Irrigation and Rural Engineering Services, UP and others versus Sahanago, Ram, Arya and another, reported in 2002 5 SCC 521. Stop para. According to Mr. Bandopadhyay, though there is no absolute bar towards issuance of direction for investigation by the CBI in exercise of the powers of Articles 32 and 226, but such extraordinary power is required to be exercised sparingly, cautiously, and in exceptional situation for the purpose of doing complete justice. Stop. The order dated 21st April 2023 does not contain any reason for directing CBI to investigate in respect of recruitment in municipalities when such issue was not even subject matter of the writ petition. Stop. In support of such contention, reliance has been placed upon the judgments delivered in the cases of State of West Bengal and others versus Sampath Lal and others, reported in 1985 1 SCC 317 and State of West Bengal and others versus Committee for Protection of Democratic Rights, West Bengal and others, reported in 2010 3 SCC 571. Stop para. He argues that the Honorable Supreme Court by order dated 28th April, 2023 permitted the appellant to move a petition by way of review and directed inter alia that the court would hear the State of West Bengal afresh on the issue as to whether the investigation should be initiated by the CBI. Stop. The assignee court, however, went on to supplement reasons to the parent order dated 21st April, 2023 and dismissed the review application without considering the grounds of review. Stop para. He contends, had it been a case that incriminating materials were found in respect of municipality recruitment scam intermingled with the materials pertaining to teachers' appointment scam, there would not have been any necessity towards registration of any second FIR, and as such, no reason is forthcoming as to why a fresh FIR was registered by CBI. Stop. It is well settled that there can be no second FIR where the information concerns the same cognizable offence alleged in the first FIR. Stop. In support of such contention, reliance has been placed upon the judgment delivered in the case of Arnab Ranjan Goswami versus Union of India and others, reported in 2020 14 SCC 12. Stop para. In course of hearing, it was brought to the notice of this court that the appellant had preferred SLP against an order dated 22nd May, 2023 passed by a coordinate bench of this court in the present appeal. However, Mr. Bandopadhyay informs that steps have already been taken to withdraw the said SLP and that as such, the present appeal may be finally heard. Stop.